Thank you.
We have only 15 minutes, and I give the floor to Mrs. Julia Legner, which is Regional Legal Officer for the Gulf for Karama Foundation. Please, you have the floor.
Good afternoon to everyone. I'm Julia Legner. I work for Karama. We are a legal human rights NGO, and we're documenting cases of torture and forced disappearance, arbitrary detention, and extrajudicial executions in the Arab world to the UN special procedures. And today I'll be talking to you about the unlawful restriction of freedom of expression in the United Arab Emirates. Over the past 12 years, Karama has been documenting hundreds of cases of human rights violations in the United Arab Emirates. And some of the most recent cases that also fall within the category of repression of freedom of expression are those of Dr. Nasser bin Raith, who disappeared last August and then remained disappeared for many months, and is now facing trial in front of the the State Security Chamber of the Federal Supreme Court. And the other is the case of the Jordanian journalist Taysir al-Salman, or al-Najjar, who also disappeared last year in December. Stayed disappeared for 4 months before being tried, even though at the moment there are still no charges pressed against him. Well, on a more general note, even though the United Arab Emirates wasn't as affected as others by the uprisings of the Arab Spring, over the past years its population has raised more and more demands for governmental reform, transparency, and political participation, which was met by the authorities by excessive repression and control, in particular to the freedom of speech, opinion, and also assembly. So now I'll be addressing the criminalization of freedom of expression through the systematic practice of enforced disappearance and arbitrary detention. So the responsible authorities for this practice are the state security forces, or Amana Dawla, which operate under the direct control of the Ministry of Interior, and they report directly to the President of the Federation. These forces, therefore, are not. No, just a second. So these forces are not subjected to any judicial oversight, and the service has its own detention facilities, as well as an exceptional justice system. That is the State Security Chamber of the Federal Supreme Court, which is responsible for prosecuting the accused in the first and the last instance, and that chamber also tries cases of terrorism charges. The proceedings before that court are characterized by gross violations of fundamental fair trial guarantees. The severe violations have regularly also been highlighted by the UN Working Group on Arbitrary Detention and the Working Group on Enforced Disappearance. The intelligence services also operate in a way that generates chain violations. Usually the victim is arrested arbitrarily, then detained in secret detention and in solitary confinement incommunicado for prolonged periods of time, during which he or she is subjected to physical or psychological torture in order to obtain confessions that will be admitted and used as evidence for prosecution in front of the State Security Chamber of the Supreme Court, resulting in unfair trial and at the outcome of which the sentence can't be appealed. So that modus operandi of the state security really creates systematic fair trial violations. So there are two very concerning issues. One is the issue of the fight against terrorism and the measures taken, and the other worrying trend is the passing of the cybercrime law. So in 2014, the Fight Against Terrorism Crimes Law was passed, which provides an extremely broad and vague definition of terrorism, and continues to serve as a legal basis for prosecution of peaceful political opponents, human rights defenders. Article 1 of the law defines a terrorist act as an act that would cause unrest or panic amongst a group of people, or that would otherwise upset the state, without specifying, for example, the violent nature of such acts, and therefore paving the way for the criminalization of peaceful acts and dissent. Under the terrorism law, the custody period can be extended by renewable 3 months periods without a detainee having to be brought before a judge. And then to the cybercrime law. The UAE cybercrime law of 2012 includes stern punishments that could go up to life sentences, imprisonment, or fines of up to 3 million dirhams, depending on the severity and seriousness of the cybercrime. Article 20, for example, of the law makes defamation charges a criminal offense. So any insult or slanderous comments towards state and its institutions would be criminalized. Also, promoting demonstrations without license online is being criminalized. So yeah, I mean, our great concern as well is the fact that the UAE authorities are pretty unwilling to cooperate with the UN human rights mechanisms, either by not responding to urgent appeals or allegations, or by responding without giving substantial information on the alleged violations, and especially in cases of disappearance, also without disclosing the whereabouts of the victim, and regardless of opinions issued by the Working Group on Arbitrary Detentions, the victim remains in custody. While the UAE has not ratified the International Covenant on Civil and Political Rights, in which Article 19 talks about the freedom of opinion and expression, it is a state party to the Arab Charter on Human Rights, Article 32 of which ensures the right to information, freedom of opinion, and freedom of expression. In the view of these circumstances, we would like to address certain recommendations to the government. First of all, we believe the UAE should ratify the International Covenant on Civil and Political Rights and its optional protocols, and the International Convention on the Protection of All Persons from Enforced Disappearance. The state security forces should be put under independent judicial control in order to stop their abuses. The practice of arrest without judicial mandate and for acts that are falling under the rights of freedom of expression, opinion, peaceful assembly and association should be stopped, and the UAE should implement the Uyghur opinions requesting the release of those still imprisoned. Stop the practice of enforced disappearance through secret detention by putting those who are currently disappeared under the protection of the law and offering redress to past victims. And lastly, we urge the United Arab Emirates Authority to amend the provisions of the cybercrime law and to revise the law on terrorism in order to restrict the definition of terrorism to acts of violence that specifically target civilians, and to put the procedure in line with international due process guarantees. Thank you.